always has two sort of feelings. One is that one triggers off, just like in Diwali we say, that one should do away with the bad habits and come with good. But on this platform, at least I can say that connecting with us was never a bad habit. So do stay connected with us. And we would rather be too happy that you can claim your rights on the basis of an adverse possession. To state therein that yes, you would like to have a position on this platform. And Mr. Raghavan is too happy. He says that don't take all the participants only on beyond law. They are also part of SRS. But I say that SRS, we are like Yamuna, but we are merged into the Ganga. And it is not at Allahabad, but on a webinar platform. And we all thought that, like when Mr. Raghavan took the first session on the adverse possession, there were a lot of questions coming within the mind of a person as to what could be the takeaways for the adverse possession. And that is why when we shared, we said that there are certain agendas which are to be discussed, that what exactly does adverse possession mean when it has not been defined in a statute itself, whether there is a difference between a mere possession and adverse possession, when does one get and claim adverse possession, and how can the owners reclaim the properties, etc. These are some of the nuances which Mr. Raghavan will take over us. And the way he takes the things is also an amazing factor. I was telling him that not only as a speaker, but as a lawyer, but as a lawyer, one needs to know about it. And also the way he takes, it's just like a class where everyone gets assimilated. The only difference between these master classes and a normal class is that there is attention whether there is an attendance or not. But here the attendance not only on the Facebook, but also on this platform. People come of its own. One, we have always heard that you are doing pro bono work. That I can say about the speaker. But I was asking and thinking with Mr. Raghavan, there is a pro bono lawyer, pro bono speaker. But what about the participants who participate themselves? What terminology we could use for them is also a facet to be thought about. Without taking much time, I will request Mr. Raghavan to take over and give us the insights. As usual, we know that it will be a fascinating session and we will take the judgments from him by the end of the day and share it in the different groups.
Thank you, because am I quite audible?
Yeah, perfect.
Okay. Last occasion, we were on the 3 exceptions where a person in possession or a third party cannot take the plea of adverse possession. They were, number 1, permissive possession. Number 2, possession handed over in terms of an agreement of sale, or the possession or part performance under section 53A of the TP Act. And third is possession by a co-owner. The third one assumes more importance because here comes the concept or a sub-doctrine of ouster. It may be, sometimes it is pronounced as ouster and sometimes it is pronounced as ouster, but I used to pronounce it as ouster only. So this third situation is where now we stand. It is the situation in which a person cannot take the plea of adverse possession is when a person is the co-owner. He is the co-owner of your land in respect of which he is claiming ownership by way of adverse possession is something impermissible in law. There is a logic behind this law. A co-owner to a property is not only acting as a representative on behalf of all other co-owners, and his enjoyment is also the enjoyment of other co-owners. So normally a co-owner cannot claim a title by prescription and adverse possession. But anyhow, every rule has an exception. So also the third exception called bar or embargo on co-owner has got an exception. That exception is called ouster. I drew the attention of the learned participants to the case law of the Supreme Court of India in the last session that was reported in 1995 4 SEC, page 496, a case between Vidya Devi alias Vidyavati versus Prem Prakash and others, where the Supreme Court has held that plea of adverse possession by a co-owner can be taken if that person is able to prove that he has ousted all other co-owners from the property, coupled with all the other ingredients to constitute an adverse possession. Two, a co-owner has to satisfy dual test or has to pass through dual test to succeed in the defense of ouster by proving two things. Number one, he should prove that he has ousted all other co-owners from the property. That is the first and foremost test one has to prove whenever he takes the plea of ouster of the property by co-sharers or co-owners. And coupled with the proof of ouster, he has to satisfy all other ingredients of adverse possession. As I said, continuous, open, exclusive, hostile, and more than statutory period possession of the property by the possessor. So ouster is something special for a co-owner to prove in a case of suit for partition or a suit between the co-owners. Now, let me decipher the ingredients of the ouster for better appreciation as follows. The judgment of the Supreme Court in Vidya Devi versus Vidyavati has given three important elements of ouster, plea of ouster, namely, number one, declaration of hostile animus. The person in possession or one of the co-owners who establishes the defense of ouster must prove that he has the declaration, hostile animosity or animus possessivity of the property to the exclusion of all other co-owners. Number two, he has to prove and uninterrupted possession of the person in exclusion of other co-owners. Or in the other way, the person who is pleading ouster should prove that he has been in enjoyment of the property and it should be a long and uninterrupted possession without the possession and enjoyment of the other co-owners. And the third is more important, the exercise of right of exclusive ownership by the co-owner who is pleading ouster openly and to the knowledge of the other co-owners. The third is very important. Unless and until the exercise of right of ownership of one co-owner is openly made known to all other co-owners, a doctrine of ouster cannot be buttressed into. Now, if we see the same case, Vidyavati's case, the Supreme Court has further held that the plea of adverse possession cannot be taken by the state or the government while justifying its forcible expropriation of the private property without following due process of law. For example, if a land of a poor man is taken by the government for the purpose of laying a road, but there was no acquisition of a land or outright purchase by the state government, that be the case, however long or however lengthy may be the period of possession by the government, since the process is not a due process of law, the government cannot take the plea of adverse possession and ouster against the individual. So such is not possible for a state according to the Supreme Court in Vidya Devi's case. There is one more case law. Unfortunately, I was not able to search the citation. If any one of us will give it, I'll be happy. It is a case between Muhyiddin Abdul Qadir versus Muhyiddin Umma. Muhyiddin Abdul Qadir versus Muhyiddin Umma, where it has been held by the court as follows. The law relating to ouster is well settled, and the difficulty, if at all, will lie only in its application to the facts of the case and the proper inference to be drawn in a particular case. So, the difficulty lies in the application of the law of ouster to the facts of the case. Because in a case of co-owners, there is what is called a unity of possession. That is what is the sine qua non of a co-personary. So since there is unity of possession among the co-owners, the possession of one co-owner or one co-sharer in law is deemed to be on behalf of all other co-owners. But this does not prevent ouster being employed or defended by the co-owner. In order to establish ouster as a special branch of adverse possession by a single co-owner, ouster must be construed to be exclusive possession of co-owner in denial of the right of the other co-owners, and it must be brought to the knowledge of the latter. So the Supreme Court in Muhyiddin Abdul Qadir's case has given two more important aspects of the doctrine of ouster, stating that there must be denial of the right of the co-owners and it must be brought to the knowledge of the other co-owners. Unless these two elements are present, ouster cannot be established. I may cite one more judgment of the Supreme Court where a karta claims the defense of ouster. Chandramohan Ramachandra Patil. Chandramohan Ramachandra Patil versus Bapu Koyappa Patil. It's reported in 2003, volume 3, SEC, page 552. 2003, 3 SEC, page 552. Equivalent citation is AIR 2003 Supreme Court 1754. AIR 2003 Supreme Court 1754, where the Supreme Court has categorically held that the eldest member in the family cannot plead adverse possession in a suit for partition unless he is able to establish ouster in the manner known to law. So, simply because he happened to be a karta of the family or the eldest member of the family, he cannot produce all the documents showing that they are all in his name. These are all the documents in my exclusive name, so I succeed in ouster. The Supreme Court says no, because it is common for a karta to hold the property for and on behalf of other co-owners. So he must specifically prove that he had denied the title of other co-owners and he has established adverse possession to the knowledge of other co-owners. That is very important. Say it in other words, I would like to elucidate as follows. To bring about ouster, the co-owner's exclusive possession must be in the nature of denial of the title of the other co-owners and must be brought to the knowledge of the other co-owners. In this respect, there is a subtle difference between the co-owner's adverse possession and adverse possession on the part of the stranger. Because in the case of co-owner, the person claiming adverse possession is not a stranger. He is one of the co-owners. In such a case, the law is little bit liberal. Between the co-owners, the law is little bit liberal because there is a reason. I would repeat, in such a case, the law will presume ouster as an explanation. Explanation of what? Explanation of the long, peaceful possession of the co-owner in possession. If the co-owner is in possession and he is able to establish that he has been in exclusive possession of the property for a long and peaceful time, and the possession is not, when the possession is peaceful and long, the law presumes ouster in favor of a person who is claiming ouster by one of the co-owners. I repeat once again, in such a case, the law will presume ouster as an explanation of the long and peaceful possession of the co-owner in possession. In order to maintain the person in such possession, the law presumes the lawful origin of the possession. So this is an important aspect of ouster. Now, we have gone through the difference between a subtle difference between ouster and adverse possession. There is one more area, I would say, which is a gray area where law of adverse possession will not have application generally by and large is the case of lease and license. These two areas, the judgments of the Supreme Court are very clear, and unfortunately, there is no clarity of thought among practitioners and some of the judicial officers because of lack of exposure to such rare cases. I will first take up the adverse possession in context of lease. Lease. Lease of an immovable property is a transfer of your right or interest to enjoy the property for a certain fixed period. The period may either be express or implied, or it may be in perpetuity and in consideration of a price paid or promise to be paid. I repeat, the lease of immovable property is a transfer of a right or interest for a certain period. The period here may be either express or implied, or it may be in perpetuity and in consideration of the price paid or price promised. With the expiration of the period, the lease may be terminated by serving the notice under Section 106 of the TPF, Transfer of Property Act. Now, there is an interesting position, what is called lease by holding over. For example, there is a lease deed for a period of 12 years. So the lease period has expired. Unfortunately, the person in possession of the property in consonance of the terms of the lease continues to be in possession of the property, irrespective of the fact that the terms of lease deed has expired. The possession is not unlawful, it is juridical, it is called a lessee by holding over, or somebody say it is lessee by sufferance. The possession taken during the lease may not be adverse. I repeat, the possession taken during the lease may not be adverse as against the lessor until termination of the lease. So here lies the very important point. A lessee to take up the debt of adverse possession should ensure that he has been in possession of the leasehold property after the expiration of the period of rest of the lease. So the adverse possession of a lessee would commence only after the expiry of the period of limitation, or expiry of the period of lease. Expiry of the period of lease. If the lessor is unable to sue for recovery of possession while the lease is still in current, it is called a lessee by holding over. No question of adverse possession or of limitation arises when possession of a person and the predecessors in title has continuity under the lease. So long as the lease deed continues, there can be no plea of adverse possession. But where the lessee has asserted an adverse title against the lessor and repudiated the agreement of sale, second, I think I made a mistake of saying sale instead of lease. I repeat once again. Where the lessee has asserted an adverse title against the lessor and repudiated the agreement of lease, he loses his right to apply for specific purpose. So, a plea of adverse possession cannot be taken into account when the lessor and lessee are not in good terms and the lessee has terminated the lease agreement. So, the occupation of a land under lease can become adverse to the real owner only after the period of expiry of the lease deed and the lessor has not taken action for recovery of the property from the lessee, and the lessee continues to be in occupation of the land without the lease being extended. Now, let's go to license. License is totally different from lease. There is no transfer of interest or right over a property in case of license. The basic distinction between lease and license, that in case of lease, it is a transfer of property by transferring a right or interest. In case of license, there is no such transfer of interest or right over the property. The occupation of a land under license is in the nature of permissive, and it can never be an adverse possession. The possession of a licensee is that of a permissive possessor, so he cannot put up or set up the defense of adverse possession. The licensee cannot claim he cannot claim title from possession, however long may be the period, unless here also there is an exception. The licensee cannot claim title only by dint of his possession, however long it may be, unless it is proved that the possession was adverse to that of the licensor, to the knowledge of the licensor, and with his acquiescence. So the term acquiescence assumes importance in case of adverse possession in the event of licensee. But the law does not entail any possession upon the licensee, unlike the case of lease. As I said, in case of lease, there is no possession or right transferred over to the licensor. So a licensee is permitted to use the licensed possession without any legal right to possession thereof. Now, where is the question of adverse possession in case of license? There must be a legal claim over the property to claim adverse possession. Therefore, a licensee who has got no transfer of interest over the property has got no right to continue in the licensed premises after the expiry of the period of license. The licensor is not only any sort of obligation either to issue a notice similar to lease or to take any steps. In the event of lease, on the expiration of the period of lease, the lessor must issue a notice to the lessee to quit the property. But that is not the case of a license. A license, in case of license, the licensor need not issue any notice before seeking the licensee to quit the property. And there is no transfer of interest or right in the property under license in case of a license, contra to the case of lease. So, where the possession of the defendant is permissive in character, being under the pure license, it is consistent with the continuance of the plaintiff's title in spite of the possession for a long time, and hence adverse possession cannot be applicable to license. But there are some cases in which a licensee is entitled to claim adverse possession. Let me explain in a different way. The adverse possession can be claimed whether licensee assumes or arrogates to himself the right of transferring the subject of the license. So here, the licensee should challenge, assumes and arrogates to challenge the right of the transferring the subject matter of the license itself, not their interest over the property. He cannot transfer, so those surely involves an assertion of an absolute title and consequential denial of title of the actual owner. So, a licensee who assumes or arrogates to himself the right of transferring the subject of the license itself, and he has refused to license subject matter itself, can claim adverse possession if he is able to prove that the subject matter of license has not been surrendered to the licensor. In such a case, the possession of the transferee must be lawful from the date of its inception. Also, if the licensee successfully sets up a title hostile to the title of the licensor after the termination of the license with continuity and require animus, claim for adverse possession can be maintained. Once again, in case of license, After the termination of the license, if the licensee remains in possession of the premises under license for an open and continuous period without interruption by the owner of the property, a licensee can seek the defense of adverse possession. So, after ouster lease and after license, let me move to statutory exceptions to adverse possession. There are some special or local laws which clearly exempts adverse possession from being set up as a defense at all. For example, let me take the example of a law in Tamil Nadu. I'm sure that such a law will be enforced in all other states, that is Hindu Religious and Charitable Endowments Act, Tamil Nadu. Section 109 of the Tamil Nadu Hindu Religious and Charitable Endowments Act specifically bars the application of doctrine of adverse possession totally to suits filed for recovery of possession of religious institutions. It need not be a temple. Even for a mutt or any other religious institution, the law or doctrine of adverse possession is forbidden. It means that if a suit is filed by the temple or any other religious institution of Hindu religion, a plea of adverse possession cannot be set up because such a plea is totally taken away because of operation of Section 109 of the HRNC Act in Tamil Nadu. Section 109 of the HRNC Act Tamil Nadu reads as follows. The heading is Central Act 36 of 1963, not to apply for recovery of properties of religious institution. Nothing contained in the Limitation Act 1963, Central Act 36 of 1963, shall apply to any suit for possession of immovable property belonging to any religious institution or for possession of any interest in such property. The amendment of the state government has been given assent by the President of India. So under Article 254 of the Constitution of India, the state law will prevail over the central law of limitation. Section 109 was amended in the year 2003. So the effect of the amendment is that till the period in which Section 109 was introduced in the HRNC Act, if a person has already established adverse possession, that is not taken away by the Act. For example, the Act came into force in the year 1961. If a defendant has already prescribed title by adverse possession of a land of a temple before 1961, his right is not taken away. If a property is in possession of a property of a temple in the hands of a person, but the 12 years period falls after 1961 or after the Tamil Nadu HRNC Act has been brought into force, the adverse possession cannot be put into operation. The date is very important. It is 30th September 1951. So if any person who is in enjoyment of a temple property in Tamil Nadu wants to set up adverse possession, he should have prescribed the title by adverse possession before 1951 and not thereafter. So there are judgments. I would like to cite only one judgment of the Madras High Court, which is of the year 2019. 2019, Volume 1, Law Weekly, page 844. 2019, Volume 1, Law Weekly, 844, equivalent to 2019, Volume 1, Madras Law Journal, page 878. 2019, Volume 1, Madras Law Journal, page 878. It's a case between a very famous temple in Madurai called Kallalagar Temple versus Rajaram. This case is in the nature of explaining an exemption or total embargo on application of doctrine of adverse possession against temple properties or suit by temples and other religious institutions. What about Muslims? A similar provision is contained in Section 107 of the Waqf Act 1995, which contains a similar bar of application of doctrine of adverse possession to suits. If I read Section 107, you can find the section of 107 and 109 of both the acts are almost akin to each other. Section 107 of the Waqf Act 1995 reads as follows. Central Act 36 of 1963 not to apply for recovery of Waqf properties. It reads, this is the heading, the section reads, nothing contained in the Limitation Act 1963, Central Act 36 of 1963 shall apply to any suit for possession of immovable property comprised in any Waqf or for possession of any interest in such property. Now, an interesting possession may come into operation. As you all know, we have the General Classes Act of the Government of India, where Section 6 speaks of the effect of repeal. For example, in Waqf Act or Tamil Nadu HRNC Act, there was a provision under which an adverse possession can be applied. And the provision has been amended in the meantime. The question is whether after the amendment, whether the right can be continued by the defendant or not. Before that, let me read the relevant provision of Section 6 of the General Class Act, Central Act. Section 6 speaks as follows. The heading is effect of repeal. Where this act or any central act or regulation made after the commencement of this act repeals any enactment hitherto made or hereafter to be made, then the repeal shall not a. revive anything not in force or existing at the time at which the repeal takes effect. The repeal shall not revive anything not in force or existing at the time at which the repeal takes effect. To understand will, let us go to one case of the Supreme Court reported in 2008, volume 9 SEC, page 306. 2008, volume 9 SEC, page 306, in a case between T. Kalimuthu versus 5 Gori Taikal Waqf. 5, F-I-V-E, 5, Gori, G-O-R-I, Taikal, T-H-A-I-K-A-L, Waqf. T. Kalimuthu versus 5 Gori Taikal Waqf. It's a landmark class judgment of Supreme Court of India on this. Volume 7, MLJ 534. In the said case, the Supreme Court has settled the law as follows. Excuse me. In the said case of Kalimuthu, the Supreme Court held that the right of action, which is barred by limitation at the time when the new act comes into force, cannot be revived by the change in law subsequently. The right of action, which is barred by limitation at the time when the new act comes into force, cannot be revived by the change in law subsequently. Under Section 6 of the General Classes Act and Section 112 of the Waqf Act, prior to operation of the repealed enactment or the legal proceeding or remedies instituted, continued or enforced or saved, any other right that has come into operation after Section 112 of the Waqf Act are not saved. So both under Section 109 of the Tamil Nadu HRNC Act and Section 107 of the Waqf Act, if any right accrues after the amendment, that cannot ripen into a right of adverse possession. So the law is well settled, but the provisions barring non-application of Limitation Act to any special or local law cannot revive a barred claim or extinguished claim. In other words, a claim which has been barred or extinguished by an amendment or a law by a local or special statute cannot be revived by the law of limitation. For better understanding of the effect of extinguishment and adverse possession, the following verdict may be gone into. This is the old case in the year 1940 between the official receiver of East Godavari versus Chava Govinda Raju, reported in AIR 1940 Madras, because Andhra was part of Madras presidency till 1956. AR 1940 Madras, page 798, equivalent to 1940 volume 2 MLJ, page 190. This is by judgment of a full bench of the Madras High Court, where the full bench of Madras High Court held that a plaintiff who is suing for possession of property in the occupation of another cannot rest his case on title alone. He must show that he has exercised right of ownership by being in possession within 12 years of the suit under old Article 142 of the Limitation Act 1963 that corresponds to new Article 65 of the Limitation Act 1963. We have seen what is called ouster. We have seen the distinction in case of lease and license. We have seen ouster in case of statutory exception under the religious laws. Now, let me move to a very important aspect of what kind of pleadings is required in a suit where ouster is pleaded and what kind of burden of proof is to be discharged. This is the gray area where most of the advocates fail. If I am not mistaken, or if I am inquisitive, or if I am though not inquisitive, I may refer to the questionnaire prepared by the Law Commission when the Supreme Court of India called upon the Law Commission to think in terms of abolition of the adverse possession. The Law Commission ventured into, I hope it was under the leadership of Justice A.P. Shah, I am not sure, ventured into some questionnaires to all the Bar Association, to all the courts, all the high courts, inviting opinion, where there is a statistics available. Very few states failed to respond to the questionnaire. According to the answers submitted by various high courts and official courts, more than 80,000 cases were pending where the defense of adverse possession was pleaded, but only in 2% of cases evidence was adduced. So I would say that CPC is no more Code of Civil Procedure. It is a copy and paste code. We used to copy and paste whatever pleading available in our computer in a similar suit, and we paste whatever plea available in the previous written statement. There are written statements where you can find that there is a plea of title based on document and also the plea of adverse possession in plains, which is impermissible. So adverse possession is invariably pleaded as one of the defenses by almost all the defendants when there is a suit for declaration of title with relating to immovable property. Fortunately, there is no plea of adverse possession in a suit for recovery of possession because it cannot be done. Now the question is, what kind of pleadings is required and what kind of burden of proof is expected? To claim the title through adverse possession, it is necessary to take into consideration what is actually required to be pleaded and what is not to be pleaded. Once again, I'll have to take umbrage under the judgment of the Supreme Court of India in Karnataka Waqf Board case, which I have cited last session, reported in 2004, volume 10 SEC, page 779, where the Supreme Court said regarding pleading to be made by a person while claiming adverse possession as follows. Plea of adverse possession is not a pure question of law, but a blended one with fact and law. Therefore, according to Supreme Court, a person who claims adverse possession should plead and show the following 5 things. A, on what date he came into possession. Number 1, on what date he came into possession. Number 2, what was the nature of his possession? What was the nature of his possession? Number 3, whether the factum of possession was known to the other party or the true owner or the defendant in case of plaintiff or plaintiff in case of defendant. Whether the factum of possession was known to the other side. Number 4, how long his possession has continued. How long his possession has continued. And finally, 5, his possession was and undisturbed. These 5 elements should have been pleaded whenever the adverse possession is pleaded either as a shield or as a sword. I repeat once again, on what date he came into possession. Number 2, what was the nature of his possession. Number 3, whether the factum of possession was made known to other side. Number 4, how long his possession has continued. And number 5, his possession was open and undisturbed. A person pleading adverse possession has no equities in his favor. Friends, please have in your mind that the doctrine of adverse possession is not an equitable principle of. Since he is trying to defeat the rights of a lawful owner, it is for the person who pleads adverse possession to clearly plead and establish all facts necessary to establish his adverse possession. The Supreme Court in the said case held that whenever the plea of adverse possession is projected, is that someone else was the owner of the property. Therefore, the pleas on title and adverse possession are mutually inconsistent or mutually destructive, and the latter does not begin until the former is renounced. So it says, whenever the plea of adverse possession is projected, inherent in the plea is that someone else was the owner of the property. Therefore, the pleas on title and adverse possession cannot go together. They are mutually inconsistent, and the latter, that is adverse possession, does not begin to operate unless the former, that is the title, is renounced. This is what is the requirement of a pleading suit, either as a plaint or as a defense. I would like to cite one more case law of the Supreme Court of the year 2017. Dagadabai, Dagabai versus Abbas alias Ghulam Rastam Pinjari. Dagadabai versus alias Ghulam Rastam Pinjari. Reported in Volume 13, Supreme Court Cases 705. 2017 13 SEC 705. The apex court held that the person first admit the ownership of the true owner over the property before claiming ownership on the strength of adverse possession. I repeat, a person should first admit the ownership of the true owner over the true property before claiming ownership on the strength of the adverse possession. Inconsistent party while claiming adverse possession. Example, when I claim title over property by a document of sale deed or something, I cannot take the plea of adverse possession because they are not only inconsistent, they are mutually destructive. This said judgment has been elaborated by the Supreme Court once again in the judgment between Aswathama versus Prakash. L.N. Aswathama and another versus reported in 2009, volume 13 SEC 229. L.N. Aswathama and another versus P. Prakash, 2009, volume 13 SEC, page 229. The Supreme Court held very clearly. Interestingly, one such plea, however, alternative and not inconsistent was allowed very rarely, but otherwise the Supreme Court said a mutually destructive plea of adverse possession title cannot be permitted. Now, let us go to the case law of Karnataka Waqf Board once again, where the Supreme Court has held, that is 2004 10 SEC page 779. The Supreme Court held that the question of adverse possession is a mixed question of law and fact, as the trespasser needs to prove a continued possession of more than 12 years with animus possession original owner. Once again, there is one more judgment of Supreme Court in the year 2004 in a case called Vasanti Ben Prahalad Nayak, Vasanthi Ben Prahalad Nayak versus Somnath reported in 2004 3 SEC, page 376, where the Supreme Court has elaborated the starting point of limitation and the commencement in clear-cut terms. Now, the burden of proof in respect of adverse possession is to be seen. We have seen what is the requirement of pleading. Now, what is the mode of discharge of burden of proof? The burden of proof in respect of adverse possession is always on the person who claims title by adverse possession. So it rests on the person who claims so. As per Article 142 and 144 of the Old Limitation Act 1908, in a suit plaintiff time, adverse possession can be taken only by the defendant. Now the law is changed. Had to prove that he had the title and had been in the physical possession of the property since the last 12 years. But the present Limitation Act of 1963, the burden is now shifted to the defendant. Now, true owner just have to prove ownership, and the onus of proving adverse possession is shifted to the defendant who sets up title for possession. There is a case law which I would like to say as a very famous case law. This case law called Ram between M. Siddiq versus Mahant Suresh Das. M. Siddiq versus Mahant Suresh Das, Ram Janmabhoomi case, reported in Volume 1, Supreme Court Cases, page 1. This is a case law where it is, as you all know, it is a suit on title of the property. It is not a writ petition. The Supreme Court in the said case held the possession has to be in public and to the knowledge of the true or real owner, actual owner first. This is compulsory as a plea of adverse possession seeks to the rights of the true owner. Thus, the law would not readily accept such a case of a defendant and cogent basis has been made out. So this is what is the requirement of burden of proof as per the Supreme Court. Then the question of, it is only a repetition, whether the plea of adverse possession can go along with the plea of title. Plea of title and plea of adverse possession cannot go together as they are mutually destructive. It is reported in a case by the Madras High Court in a very clear and unambiguous terms, reported in 2020, Volume 3, Madras Weekly Notes Civil, page 245. 2020, Volume 3, Madras Weekly Notes Civil, page 345, Narasamma versus Krishnappa. Now, the last phase of the session, we have got 10 more minutes only, that deals with whether adverse possession is a shield or a sword or both. What I mean as a shield is a defense. So I mean to say whether adverse possession can be taken to be a defense only, or can it be a plea in the plaint also? Or in other words, whether adverse possession can be a cause of action in a suit for declaration of possessory right, or whether the plaintiff can file a suit for declaration of title on the basis of adverse possession. I would reframe it as follows. A question arises. If a plaintiff can set up adverse possession as a cause of action to seek the declaration of title, whether he can use adverse possession as a sword, or whether the plea of adverse possession is available only as a sword or both as a shield and sword, is the final phase of our session. Let me go to the case law of Privy Council, which I dealt with in the previous session, reported in 1907 is appeal cases, page 73, in a case between Perry versus Clissold. Perry versus Clissold. The Privy Council has held very clearly, this is the basic of the change of law by the Supreme Court. The Council held as follows, please follow closely. If the rightful owner does not come forward and assert his title by the process of law, time period prescribed by the statute of limitation applicable to the case, his right is forever extinguished. And the Privy Council did not stop there. It further continued by stating that the possessory owner acquires an absolute title. This is why I told on the extinguishing of the right of the plaintiff by filing a suit for recovery of possession on the expiry of 12 years according to section 27 of the Limitation Act, not only his remedy is barred, his title is also extinguished. Now the question is, can the title swing in the air? I said it is not so. A title cannot swing in the air, the title cannot be vested in nowhere, and the title should be vested to somebody else. This is where the Supreme Court held in a case dealing with old Limitation Act corresponds to section 27. Mahant Bhagavan Ramanuj. Mahant Bhagavan Ramanuj versus Ramakrishna Bose, reported in AAR 1922 Privy Council 184. Why I cite this old case law, though it is century-year old, it's a classic case law on this subject. It is under the previous law of section 28, correspond to present section 27. According to the Privy Council, under section 28 of the Indian Limitation Act, it is expressly provided that at the expiration of the period of limitation, not only is the remedy barred, but the right is gone. This is quite clear that being so, the statute has operated to revoke the title that was originally vested with the plaintiff, and it confers a title upon the defendant. So now let us pose the question, can a suit for title be filed on the basis of adverse possession? For some reason, I don't know why, the Supreme Court of India has been holding it in the negative only. I would say in one more case, in AR 1942 Privy Council, page 184. AR 1942 Privy Council, page 184. Lala Hebchand versus Lala Pyarelal. Lala Hebchand versus Lala Pyarelal. The Privy Council took a view that the plaintiff had acquired title by prescription, and the title of defendant has been prescribed. In Bahadur of Murshidabad versus Gopinath Mandal, reported in volume 6 Indian Cases, page 392, the Calcutta High Court has held that the effect of section 28 of the Old Limitation Act therefore is not merely to extinguish of the rightful owner, but also to create a title by negation of the occupant, which he can actively assert and conferring title against the true owner. Now, we come to a very important case law of Supreme Court of India in the year 2007. It is called the P.T. Munichikkanna case, which I dealt with already in the last session. P.T. Munichikkanna Reddy versus Revamma and others, where the Supreme Court held by acknowledging the effect of adverse possession as follows. Modern statute of limitation operate rule not only to one's right, but to bring an action for the recovery of property that has been in the adverse possession of another person for a specific time, but also to vest the possessor with the title. The intention of such statutes is not to punish one who neglects to assert the right, but to protect those who have maintained the property, the possession of the property, for the time specified by the statute under a claim of right or color of title. So now the question that what is the stand of the Supreme Court subsequently? There are three cases I want to cite. Please go through when you find enough time. Balakrishnan versus Satya Prakash, reported in 2001 2 SEC 498. 2001 2 SEC 498. Number two, Bandar Singh versus Nihal Singh. Bandar Singh versus Nihal Singh, 2003 4 SEC, page 161. And Desraj versus Bhattram, 2007 9 SEC, page 641. Desraj versus Bhattram, 2007 9 SEC, page 641. The Supreme Court upheld decrees for declaration of the plaintiff's title on adverse possession. But the blow came in the year 2014. The Supreme Court made a volte-face or a somersault in a case between Gurudwara Sahab versus Grama Panchayat of village of Sirtala. Gurudwara Sahab versus Grama Panchayat of village Sirtala, reported in 2014 1 SEC page 669, where the Supreme Court took a contra view. The Supreme Court took a contra view and held that the plaintiff could not set up adverse possession to seek declaration of title. If I verbatim reproduce the verdict of Supreme Court in the Gurudwara Sahab case in 2014, it would read as follows. Even if the plaintiff is found to be in adverse possession, it cannot seek a declaration to the effect that such adverse possession has matured into ownership. Only if proceedings are filed against the appellant is arrayed as a defendant that it can use this adverse possession as a shield. So according to Supreme Court in the case of Gurudwara Sahab versus Grama Panchayat of village Sirtala, reported in 2014 1 SEC page 669, adverse possession can only be a shield and not a sword. Do you think the law is settled? No. The debate continued and continued and continued till 2019. After 2014, under Article 141, the states and the Supreme Court and the lower courts and the high courts are bound by it. So, high courts across the country have started holding that the suit for declaration of title on the basis of adverse possession is not maintainable, since the plea of adverse possession is only a shield and not a sword. The reason being, the intersection 27 of the Limitation Act would operate only when plea of adverse possession is established by the defendant in an action for possession based on title. But with all respect to the courts, with due respect, I disagree. I find no reason to agree that Section 27 to admit such inference. Such a position, if prevails, would present a challenge to a person who perfects title by adverse possession, in that he may be precluded from instituting a suit for declaration or injunction to protect illegal dispossession or recovery of possession dispossessed illegally. For example, 12 years the plaintiff did not do anything to dispossess the defendant. On the 14th year, he wants to recover the property. Section 27 debars it. So whatever done by the plaintiff to forcibly evict the defendant would be something unlawful. If the courts don't recognize the property right of the possession of the defendant, is it not something unlawful? That is not the purpose of the Section 28 Act. It would be inequitable that in such circumstances, the person who perfected title by adverse possession no remedy in law against interference by person whose title stood extinguished by virtue of Section 27 of the Limitation Act. Further, in such a case, the property would remain without an owner at all, because if you say Section 27 cannot be put up by the plaintiff, the person who is the rightful owner has got his right extinguished becomes not the owner. The person who is in occupation of the land for more than 12 years is also not a owner. Then who is the owner? As I said, the title cannot vest in what is called a swing or pendulum. So I disagree with the proposition as an advocate and academician. The proposition of law that the limitation under Article 65 of the Limitation Act allows the defendant to take up the plea of adverse possession as a shield in a suit initiated against it, or can it be taken by the plaintiff as well to protect the possession of immovable property not raised earlier in Gurudwara Sahib, was taken up in this case in 2014. Now, we will go to one case called Fakirappa versus Ningappa. Fakirappa versus Ningappa, reported in AR 1943, Bombay, page 265. The Bombay High Court held the title to immovable property cannot be left in the air, and it is clear that on extinguishment of the title of the true owner, the title must follow possession and vest in the trespasser who has got title by his possession. So, Gurdwara Sahib's case has come as the principles and letter and spirit of Article 65 and more importantly, Section 27 of the Limitation Act. And even there are a lot of courts have held that a plea of adverse possession can be taken up by the plaintiff. So, the reprise or the relief or the change of law or the one more old farce came from the Supreme Court in the year 2019, where the Supreme Court has held by reversing the Gurdwara Sahib's case and stated finally, I setting the law that adverse possession is both a shield as well as a sword. This ruling of Supreme Court in Gandha Sahib's case has been overruled by the Supreme Court in a case called Ravinder Kaur Griwal versus Manjit Kaur and others, reported in 2019 8 SEC page 729. Ravinder Kaur Griwal versus Manjit Kaur, reported in 2019 8 SEC page 729. The Supreme Court, after examining its earlier judgments, held that column 3 of Article 65 of the Limitation Act, which reads that the limitation of 12 years runs from the date when the possession of the defendant becomes adverse to the plaintiff, never suggests that this suit cannot be filed by the plaintiff for possession of immovable property or interest therein based in title acquired by way of adverse possession. So, the Supreme Court further observed in Griwal's case that the expression used in the opening part of column number Article 65 would include title acquired by the plaintiff by way of adverse possession. This is a very important point. We have to plead in a plaint where we raise the plea of adverse possession as a sword. Title, the word title part of column number 1 of Article 65 would include title acquired by the plaintiff by way of adverse possession. So the Supreme Court held that a person who has acquired his title by way of adverse possession can file a suit for restoration of the possession in case of dispossession, and therefore concluded that the plea of adverse possession can be used both as a sword as well as a shield. This has been followed by the subsequent benches of Supreme Court in another case which is not reported. You may kindly note down the case law. Gurtej Singh, RTEJ, Gurtej Singh versus Zora Singh in civil appeal number 8424 of 2009 and judgment dated 26/2/2020. By the same, it would have been reported. Gurtej Singh versus Zora Singh in CA number 8424 of 2009, judgment of Supreme Court dated 26 February 2020 by Justice Sanjeev Khanna and Justice Krishna Murari, a full bench, that the plea of adverse possession can be taken by the plaintiff also. So the law is very clear that it is a sword as well as a shield. And finally, I would like to cite a strange position of law in Tamil Nadu, which might be the position in other states also. Tamil Nadu government has amended the Court Fees Act. They have introduced a new proviso to Section 30 that says that where a defense of adverse possession is taken, the same shall be deemed to be or treated to be a counterclaim. So, according to Section 30 proviso of the Tamil Nadu Court Fees Act, even when there is no plea of counterclaim by the defendant, a plea of adverse possession will be deemed to be a counterclaim. And Section 25CC of the Tamil Nadu Court Fees Act mandates the courts to charge court fee or levy court fee on the market value of the property, though the adverse possession is not pleaded as a counterclaim. I would humbly say that the provision of law requires a revisit or review by the courts, because unless and until the defendant seeks to establish or declare his title by way of a specific adverse possession, there is no automatic conferment of title by the court whenever a plea of adverse possession is taken up. So, without a plea in the nature of adverse possession as a counterclaim, charging a levying court fee is inappropriate in my humble opinion. I expect the High Court of Madras and the Supreme Court would apply the doctrine of reading down to see that the term deemed adverse possession, what is called deemed counterclaim, should be read down to be an actual counterclaim. With this, I would conclude my second adverse possession and I hand over the mic to Mr. Vikas. Thank you and Jai Hind.
First of all, I would like to congratulate that since you have also been holding webinars, if the participation level continues to remain the same, it means that people have actually enjoyed it. It is an excellent session.
Thank you.
On behalf of all the participants, I would first of all congratulate for that purpose. That the variation, I would say, in the entire webinar was less than 10%. The exit is only of 3 participants. So that itself shows that people have actually thoroughly enjoyed. That is the second question as to whether they would claim an adverse possession over you or they would claim. As to how it will be used as a sword or a shield is a separate matter to be discussed. Before we take the questions, because we had promised them, because since you come from Tamil Nadu, a lot of people said that kindly conclude in Tamil. So 5 minutes, though I will not be able to understand, but since I promised that I will request you, so in 5 minutes, whatever conclusion you can do, and then I will request you yourself or Adi Lakshmi to take a session in Tamil ultimately. Not here,
Okay.
because at least I will not be able to understand anything.
Okay, but
what can be done is I will take the questions and then in the last 5 minutes you can explain it.
That will be better.
Yeah.
That will be better.
Yeah, because once we take the questions, the people who will willing to take the questions, they will not understand.
Yes. So you want to go to the question first?
Yeah. Dharam Raj. Father's property, 2 sons, 1 is out of station. Property is in possession of the 1 brother. Father has died. Whether possessionary rights to 1 brother in possession after 12 years or what is his position?
Yeah, of course, for ouster also, the period is only 12 years. But as I said, in addition to adverse possession, the son who is in possession, who is a co-owner, should establish his clear-cut act of ousting the other co-sharer. Simply because the defendant resides outstation, there can be no inference of ouster. There must be a specific pleading that knowingly, by defying or denying the title of the other co-owner has been ousted. The mere separate residence by the another son by voluntary action of residing outside the country or state or city cannot amount to ouster. And he has to understand that first. There should be an ouster. Ouster is a positive act. And there can be no ouster when a person goes out of the property either on account of employment or something else, because there is no ouster by the co-owner in possession.
S.SRINIVASA, he says, if it is not known to the true owner of the adverse possession by other, claim of adverse possession, whether it can be made or not.
No, sir. It must be, that is what is called open and exclusive possession. Open means it must be known to the real owner. Animus possidendi must be made clear. It is, I told last session, it does not require that the person has to go to the top of the temple tower or top of the church tower and ring the bell and declare that here I am. Oh, that is not the law the law says. But when the neighborhood knows, when the person who passes through the land knows, when the person who is a spectator knows that somebody else is enjoying his property, it will reach the person. And we are living in the internet world. By a click of your mouse, the entire world is knit together. So unless and until the real owner is made known of the possession of the adverse claimant, there is no adverse possession.
Yeah. Mr. Dharamraj, who had asked the question, he acknowledges with the thumbs up.
Yeah, I welcome his questions, sir.
Yeah, there are 2 thumbs up. One is for the drink, and 1 thumbs up, the soft drink which we cherish, and the another thumbs up once if he enjoys.
Thank you.
This is by Shri Nikiteshwar. In a typical case where the plaintiff and defendants are both squatting on the government land, the plaintiff obtains grant of immovable property into his name and later tries to dispossess the defendant for his possession. How can such defendant defend his property, which is also an adverse possession against the government?
Unless and until both enjoy the property together As against the government, there can be no joint adverse possession by two persons. In case of clash of interest between two persons, there can be no adverse possession by them against the government. It's very clear. There can be adverse possession by two persons, but they should enjoy the property together. And if they are divided among themselves, there can be no adverse possession because the possession must be exclusive by the joint tenants together. There can be no separate possession by two persons. That means there is no joint possession by the tenants in common. So that is not the case, so they cannot do so.
So since there are no questions, as we had promised, 5 minutes wrap up in Tamil. Because they say
I think
just like music, one can always understand. So one can always enjoy good knowledge also in a different language. Like they say,
to be frank,
we don't have any a language as such except one can understand. Same as the knowledge.
no, I would say what I'm going to talk in Tamil will be in English before they do that. I'm very happy to know that our Prime Minister was able to cite a poem of best poet India has ever produced, a son of the soil called Subramanya Bharati, before the Sardar Patel statue. Mannum Malaye Ime Malaye. It's one of the very famous poem. And we are proud of Subramanya Bharati as a product of son of the soil of Tamil Nadu. So we salute our Prime Minister for having made the poems of Subramanya Bharati a great patriot, made known to the entire world by his speech before the Patel. So my talk in Tamil would be in appreciation of the unity, irrespective of the cultural ethos and values, and our strength is unity because we are first Indians, and language second, and caste and community third. So இனிய தமிழ் மக்களே, நாம் அனைவரும் இந்தியர்கள். முதலில் இந்தியர்கள், இரண்டாவது தமிழர்கள், மூன்றாவது நமது இனம். இப்போது நமது இனம் வழக்கறிஞர் அல்லது நீதித்துறை சார்ந்த இனம். இதில் வழக்கறிஞர் என்ற பேதமோ நீதிபதி என்ற பேதமோ இல்லை. அந்த வகையில் இந்த வகுப்பு அல்லது இந்த என்ன சொல்வது, இந்த வகுப்பு என்றுதான் சொல்ல வேண்டும், இது உங்களுக்கு உதவிகரமாக இருந்திருக்கும் என்று திறமாக நம்புகிறேன். இதற்கான முன்னெடுப்புகளை கடந்த 2 வருடங்களாக நான் மேற்கொண்டு வந்தேன். இந்த வகுப்புக்காக அல்ல, என்னுடைய சட்டக்கல்லூரி காலத்திலிருந்து ஹாமுராபி கோட் என்ற சட்ட கோட்பாட்டை படித்த காலத்திலிருந்து எனக்கு இந்த கான்செப்டின் ஆஃப் அட்வைஸ் பொசிஷன் மேல் ஒரு எதிரடை அனுபவ பாத்தியம் என்ற கோட்பாட்டின் மேல் தீரா காதல் உண்டு. அதன் தொடர்ச்சியே இந்த ஆராய்வு. இந்த ஆய்வுக்கு பிறகு என்னால் ஓரளவுக்கு இந்த எதிரடை கோட்பாட்டை பற்றி விளக்க முடிந்தது என்றால் அதற்கு எனக்கு வாய்ப்பளித்த தமிழ்நாடு நீதித்துறை பயிலரம் என்று சொல்லப்படும் தமிழ்நாடு ஜுடிஷியல் அகாடமி ஒரு முக்கியமான காரணம். அதனுடைய கோயம்புத்தூர் மண்டல நிலையத்தில் இதற்கான ஒரு வகுப்பை எடுக்கக்கூடிய வாய்ப்பு எனக்கு கிடைத்தது. அந்த வாய்ப்பின் நீட்சியே தற்போதைய வகுப்புகள். எனவே இந்த வகுப்பு தங்களுக்கு உதவியாக இருக்கும் என்று நம்புகிறேன். வணக்கம் வணக்கம் வணக்கம். Thank you, Mr. Vikas. I told just that I started this session because of my love on the adverse possession from my law college days, and I have worked for more than 2 years because of a webinar given by Tamil Nadu State Judicial Academy to me, and this session is only extension of what the session I have done for them, and I'm happy to share my knowledge, very much little, with all the persons concerned, and I conclude with saying that Dhanyavad, Shukriya, and Vanakkam, and finally Nandri. Thank you, Vikas.
Yeah. Then we can also conclude, once we conclude for today, that as they were saying, they say Shabbat Khair. So, and all we should enjoy the session the way you have concluded. Before we proceed for the day, only tomorrow's topic. And I can tell people that I was thinking that we should stop, but you motivated me that no, we should continue with more of the webinars. I thought that we should make it now on the weekends, either one Wednesday and one Sunday, or either Wednesday and Saturday. But you said no, we should continue series. So it's all because of people like you that we keep on get motivating. So tomorrow's session, as we all talk, that it's not always law, but something we have beyond law as the topic suggests. So tomorrow, as we always do, one session in the week, which is where we don't talk of law, but soft skill developments. And on the same lines, tomorrow it is careers and new challenges, a thought process and an attitude for 21st century. It is by Mr. K. Siddhartha, strategic thinker and perception management, consultant to not only national but international government agencies. And it would be moderated by Professor Puneet Sharma, who is also an anchor of DD. So do stay connected with us at 4 p.m. From Wednesday onwards, we will be starting the new labor law series every Wednesday at 4 p.m. We have a senior advocate from Karnataka joining us. So for tomorrow, we will meet. And thank you, Mr. Raghavan, for giving the insights. And it was actually a session wherein we have been learned a lot of different perspectives. And I would request you, and though you have already seated, that the judgments which you have referred should be cited, should be given to me so that I can share it on the WhatsApp group.
Sure, sir. Sure.
Thank you, everyone.
Thank you. Thank you.
Right.
Thank you.